guys, and welcome back to Gov with Gabby. My name is Gabby Zanis, and today we're going to be talking about the required Supreme Court case for the AP Gov curriculum, Gideon versus Wainwright. Let's get right into it. So, Clarence Earl Gideon. He has an 8th grade education, he ran away from home, and he's been convicted of multiple crimes. In 1963, Gideon is charged with breaking into a bar in Panama City, Florida, and stealing a bottle of wine and money from the cash register. Gideon does not have the funds, he doesn't have the money to get his own attorney, so he's thinking that the judge will be able to appoint him an attorney. So when he gets to the court, he asks the judge, "Hey, can I have an attorney? Can you appoint me an attorney for this trial?" And the judge denies his request because he says that the Florida law only requires to give and appoint attorneys to poor defendants who are charged with capital offenses. Capital offenses mean the death penalty. So Gideon is forced to represent himself at this trial. He doesn't have an attorney or someone who knows all of the ways of law, so he has to make his own opening statement and all of the cross-examination and present his own witnesses, and he only has an 8th grade education, so he doesn't know how to do these things. So he isn't adequately equipped to be able to represent himself without an attorney. The jury finds that he's guilty and he sentenced to 5 years in prison, but Gideon decides that he's going to petition to the Supreme Court because he thinks that he should be allowed and provided an attorney because he doesn't have the money to get one on his own. And then Supreme Court agrees to hear the case. So what is the big issue? The big question is, does the 6th Amendment right to counsel apply in all cases, even those not involving severe penalties? And does the 6th Amendment right to counsel apply to the states? Well, the Supreme Court rules 9-0 in favor of Gideon because the 6th Amendment right to counsel applies in all felony cases, not just like Florida said with the death penalty. The 6th Amendment applies to the states under the Due Process Clause of the 14th Amendment, where we talk a lot about selective incorporation, or federal laws slowly incorporating through Supreme Court cases to the states. States must guarantee that the poor have a right to an attorney. People who are too poor to afford an attorney shouldn't be required to represent themselves. It doesn't encompass a fair trial. They should be provided with someone who will represent them and know exactly what all the law terms mean, because a lot of the stuff can get really confusing. So why is this important? In 1972, the Supreme Court extends the right to counsel to include misdemeanor cases. The right to counsel applies at any critical stage of a critical proceeding, such as questioning by police, in addition to trial. Counsel must also be effective. That means that a defendant's attorney must be competent and helpful to the legal situation. Counsel must be effective. So someone can't just have an attorney just because they're poor that's really bad or doesn't really know what they're talking about. Because then it's just like, okay, you're really poor, so you get this really, really bad guy who doesn't really know what they're doing. No, they must be effective in helping you defend yourself. And a defendant may waive the right to counsel, but only if the defendant does so voluntarily. So Gideon should not be required to represent himself. But he does have the option to say, no, I do want to represent myself, and I want to waive my right to counsel, but this must be voluntary. He should not be required to represent himself. Thank you guys so much for watching AP Gov with Gabby. Our exam is in just a couple of weeks. If you want to get a 5 on your AP exam in May, make sure to subscribe, like, comment down below, and hit the notification bell for your remaining Supreme Court cases. Thank you. Bye.